question.
Well, thank you. I'm also a repeat visitor to this forum, and I'm delighted to be here today. As Io really summarized my presentation so well, I almost feel we could go to the coffee break, but I will say a few things. I teach, as Io had said, I teach ODR, ADR, and civil procedure at the University of Haifa law faculty. And this presentation today really brings all of this together. I'm going to speak about the new generation court system in Israel, or the NGCS, which is basically the Israeli digital court project. It includes an e-filing, online service of process, and elaborate case management components, no online proceedings themselves, but everything but the proceedings themselves is managed digitally. I should start by saying I'm not part of this project. I am commenting as an external observer based on public materials, presentations, and some interviews I've conducted with people from the court administration office. Now, as for the presentation, brief as it shall be, I will start with explaining why I find this case study interesting. There are several, even many, projects of digital courts going on across the world. I'm not familiar with all of them. I'm familiar with some of them, and I find some of the features of the Israeli digital court project particularly interesting. I hope to share that with you. I will then turn to describe the project really briefly, just skim through it and focus on what I find most relevant for my purposes, and use that description to highlight both the benefits and significance of the project and its limitations. And then I'll tie back to my opening remarks, which I'm going to start with in a second, and offer some concluding thoughts on how we should perceive the role of technology in dispute resolution, in designing justice systems. So why is this NGCS project interesting? Well, as Io has so eloquently said, usually when we think of the introduction of technology into the courtroom, we think of it as a technical procedural change. It is accompanied with an amendment to procedural evidentiary rules, and we often describe it as something that is going to make the procedure more efficient, more convenient. And I see this view as a one-dimensional view, which I refer to as the efficiency paradigm. What I would like to promote today in my talk is an alternative approach, one that sees the potential of new technologies in advancing a wide range of procedural values, including efficiency, but not only efficiency. And I term this approach a multi-dimensional learning paradigm. One important byproduct of this alternative approach I'm promoting is, at least I claim so, is that this would strengthen the legitimacy of justice systems in the case of the Israeli system, of the Israeli court system. Legitimacy is an important value for justice systems, and it is often, but not always, promoted by added efficiency. So this is really something we should keep in mind. I'd like to spend a few more moments explaining what I mean by each of these paradigms, efficiency versus the multidimensional learning paradigm. So when we talk about efficiency, we're really talking about a rather thin view of procedure and the role technology can play in the design of dispute resolution mechanisms. This paradigm, I think, is characteristic of the NGCS, the Israeli project. It's also really characteristic of, I think, most of the digital court projects, and this is should come as no surprise. As we've heard, most court systems are heavily backlogged. And indeed, if we look at the Israeli project, the NGCS is one of several steps taken since the 1990s to enhance the efficiency of the court system. And we can include among these steps the early computerization steps taken, the institutionalization of ADR, which includes mediation, arbitration, what we call judicial compromise, and is really the main way in which ADR has been institutionalized and is very controversial, the establishment of a small claims court, also in the 90s, and the establishment of case allocation departments, or CADs, which are sort of supposed to manage the allocation of cases and the referral to ADR within the court system. These steps in general, or their implementation, has not been satisfactory. The performance of these CADs has tended to vary. Referral to ADR has often been arbitrary. And the measures to increase efficiency have come at a significant cost to the system's legitimacy. Parties and attorneys are feeling that they are subjected to fast procedures that come with little, if any, monitoring or quality control efforts. Now, as opposed to this efficiency-based paradigm, the multifaceted approach recognizes the fact that procedural choices impact several values. These values include, as Io had already mentioned, the quest for truth, fairness, justice, all important, and yes, efficiency, legitimacy, stability, predictability. No procedural system can advance all values simultaneously. A particular procedural arrangement represents a mix of these values. And this mix is a balance, promoting some values at the expense of others. For example, we can think of a procedural rule that allows parties to reopen, retry cases, say instead of twice through an appeal, 3, 4, 5, an unlimited number of times. Such an arrangement obviously places more importance on the value of truth than on predictability, stability, even efficiency. It could both enhance legitimacy in that it would uncover more wrongful decisions, but it could also undercut legitimacy because it could produce many contradicting court decisions. This is not to say efficiency is not important. It is obviously an important value and has bearing on other values as well. A more efficient system enhances access to justice. A more efficient system is one in which parties can not only get into court, but actually enforce their rights. And this is obviously related to the legitimacy of the system as well. Nevertheless, the focus on efficiency as the dominant paradigm has tended to overshadow the role other values can and should play in procedural design. And what has, to a great extent, been a means to an end has become an end in and of itself at the expense of these other competing values. So the introduction of new technology, as is happening in the MGCS project and other similar projects, impacts procedural values by upsetting the particular mix of values that existed beforehand. Moreover, the new technology itself and the way in which it is incorporated or implemented in the courtroom is not value-free either. But the introduction of technology, as I have said, has often been perceived as being solely about efficiency, a perception that has prevented us from fully realizing the potential that technology has for advancing a wide range of procedural values, making these systems better systems, fairer systems, systems that promote equality, stability, legitimacy, other values that are currently neglected. The MGCS similarly takes this approach, but, as I will have a few moments to show you, lays the foundation for the different approach that I'm trying to promote, and really creates the basis for this learning paradigm that I think provides us with a fuller understanding of what technology can do for us when we design justice systems. So I said that as a byproduct, the fuller understanding of the role of technology can enhance the legitimacy of the systems. And For those of you not familiar with the Israeli system, I can tell you that Israeli courts are facing a real legitimacy crisis in the past few years. Since the 1980s, Israeli courts have shifted from a formalistic, rules-based approach to an approach that openly admits the existence of discretion and the role played by values in their decision. These trends have also permeated the procedural milieu, which was perceived as the last frontier in providing some limits to judicial discretion. This is not to say that these changes have been all negative, not at all. They've had some really important impact on constitutionalization of rights and on curbing party behavior, but they have come at a cost to legitimacy. And I think that it is in this domain that the introduction of technology through the NGCS and in other projects and in other dispute resolution processes can play a key role. So before I explain how, I'd like to just quickly give you a sense of what this project looks like. I'm not going to talk about the history. It's not that long of a history, and I think we can skip it. Basically, the project is comprised of 5 features: the electronic file, the workspace, task assignment feature, calendar, and e-filing. And I've taken these 5 features from Boaz Okun's presentation. Okun was the former head of the Court Administration Office and really the architect of this project, the leading force behind it. He recently resigned, but the project seems to have come far enough ahead so that it will not be stopped at this point. It is already being piloted in various courts and expected to be launched next year, although this may be somewhat optimistic. I'll briefly review these different points in order to illustrate how the system now puts an emphasis on efficiency and to try and expose those places where the system has laid the foundation for a fuller, more comprehensive approach, but has not really taken that opportunity forward. So basically, the electronic file means that everything but the court proceedings is available and accessible digitally online for the judge, for the attorneys on the case, for court personnel, and for certain court administrators. They see the court file as a link. It's easily searchable, easily accessible. This is obviously very efficient and makes work much easier for all involved. Also, is more secure in many respects. The paper files, as all of you know, have tended to be quite hefty, at times occupying boxes of documents. Every time a judge had to make a decision, the boxes would have to be carried up to their chambers. Many times papers got lost. And so in a sense, this is a more secure system. But as we all know, these systems are never fully secure. Workspace, the system, and you can see how these points that have been created by, have been termed by Boaz Okun, really represent sort of the perspective of the court system. So the workspace refers to the judges, is very convenient, accessible, efficient, allows them to reach relevant materials, search across different types of documents through key terms, add private comments that are not viewable by others, public comments. Through them they can, for example, amend the protocols, create their own work scheme, which is very efficient, which allows for automatic scheduling of cases before such judges instead of having to devote energy and time to scheduling each case. And also creates the basis for learning through documentation. Now, for our purposes, the most interesting feature, I think, is the task assignment feature. And what has been done here is really an arduous task of mapping all the different types of proceedings handled by Israeli courts. They have taken the various types of proceedings, civil, criminal, employment-related, whatever, administrative, all proceedings held by these courts that are subject to the jurisdiction of the Court Administration Office, and really mapped out the different stages and steps involved in each type of proceeding. So you have these trees of steps that are taken in each proceeding, and each step, termed a task, was linked to a task performer. And this is really important in several respects. First of all, going through this elaborate mapping has allowed for increased automation. So tasks that previously would have to be performed by individuals can now be automatically performed by the system. For example, the allocation of court cases to judges can be predetermined according to specified criteria. And this is an obviously sort of efficiency type consideration. But a more subtle point, no less important, of a benefit that has to do with this mapping is that it serves to enhance accountability. By linking the tasks with a person in charge of performing them, we actually make sure that there are less tasks that fall between the cracks. We create incentives for people to do them well, do them quickly. And when they're not performed well, we can actually assign responsibility, which has been difficult to do up to now. And finally, and perhaps this is the most important point I'm trying to make, is that this fine-grained mapping of procedures allows for improvement and learning on a system-wide basis, which extends beyond efficiency. This mapping of every step involved in the process allows us for endless possibilities of looking back and trying to figure out how the system works and what are the impacts of how it works. Think of comparison among different types of judges, civil versus criminal judges sitting on extension of arrest requests. Do they treat the suspects differently? Do they treat Arab suspects differently from Jewish suspects? We can think of endless ways of examining not only if the system is efficient, but if it's fair, and promote legitimacy through that. The way that the NGCS people have looked at this feature is really efficiency-oriented. For example, how many cases are actually heard in an hour, and how that should affect the way we schedule cases. So this is a real efficiency approach, efficiency-based approach, which could be made much more elaborate. Calendar is just this automatic assignment of cases instead of having to do this manually. And e-filing, which makes a big difference for the legal community, is the possibility for remote filing and service of process 24/7 using a smart card and password. The system remains voluntary in the sense that paper filing is still possible, and then the court people scan all documents to have a full database online. So I want to return to my opening remarks and first start by addressing the limitations of this system. And the limitations can be put under one of two headings, I think, somewhat contradictory, but nevertheless true. In certain respects, the system does not go far enough. In other respects, it goes too far. So it doesn't go far enough, even within the efficiency paradigm. Much more could have been done, and it may be done. I mean, obviously, we are looking at the system in its early phases, and part of the approach was to get something going and then improve it. But even when we think about efficiency, the opportunity could have been seized to get rid of procedural rules that are simply superfluous. One good example is the whole area of subject matter and personal jurisdiction, which are the rules that determine which court we turn to when we have a problem. Which court in terms of what type of court, and which court in terms of where is it located. And my claim is that the parties should not have to deal with this issue at all. They should be able to send the claim to one central virtual address, or if they're filing by paper, to one central address, and the court system could very easily, through this system, address these questions. And this would enhance efficiency because it would really get rid of years of litigation conducted on these entry questions. And really, there have been litigations that have centered on these issues for years, without even getting to the subject matter of the litigation. And also, the system could decide on allocation of cases to courts based on other considerations, such as how busy the courts are, and to be able to allocate the cases. So this is even within the efficiency paradigm. This does not go as far as it could. Other examples are by addressing the full range of issues that have to do with the impact of technology on civil proceedings, getting rid of rules like the best evidence rule, which basically bars copies of documents from being introduced as evidence. This is a rule that is really from the print era and is no longer a good way of discerning credible documents from non-credible ones. These rules obviously affect other values as well, but I won't get into that now. And perhaps most importantly, as I said, the system does not go far enough in realizing the potential for promoting learning that extends beyond efficiency. Learning that could touch on other values, other procedural values, and as a byproduct, as I said, enhance the legitimacy of the system. The system also, one example could be, for example, refining ADR criteria. As I said, right now, referral to ADR is just done wholesale, arbitrarily. And we could think of a system that really uses initial criteria and studies the way in which the criteria for referral to ADR and ODR, actually, whether such criteria proves to be successful when we go back and evaluate whether those cases should have been referred to or not, and continuously refine and learn about what the relevant criteria should be, what types of processes should certain types of disputes be referred to, how can we determine who the appropriate third parties should be. All this is not being done and could, I think, quite easily be incorporated into such a system. In other respects, this system does not, it goes too far. And I think the first point is kind of obvious and is always true in these types of systems. It's always premature. You never iron out all the details, and that obviously hinders efficiency. But the second point, I think, is more interesting, and this is a point that Professor Katch had mentioned to me. When he was in Israel, he had heard Open's presentation on the system, and he had mentioned that he thought that it would be very difficult for judges to lose control over the calendar, as happens in the system. And I think this point is really part of a larger point about the intrusiveness that comes with enhanced accountability and transparency. And it is an important question to ask whether the actors, whether the parties to this system are ready for that and what impact this will have on them. And I think the judges will prove to be a difficult crowd in this respect. So I hope I've convinced you that this is an interesting and instructive case study in thinking of the significance of technology for dispute resolution system design. The NGCS very much reflects the efficiency paradigm, but also, as I said, lays the foundation precisely because of this mapping of procedures it has undertaken, lays the foundation for a much broader, more comprehensive approach, and really opens up the door to move beyond the thin description of technology as efficiency and see the potential for enhancing fairness, accountability, and legitimacy through technology. Legal proceedings in Israel, as I have said before, have undergone dramatic changes that can be traced back to the 80s and 90s. And these changes have included a real shift from rules to standards, mainly the adoption of a good faith standard, and the growing impact of basic laws, the Israeli constitution, on substantive and procedural law. And these changes have underscored the importance, among others, of procedure and procedural values, strengthened access to courts, and curbed opportunistic party behavior. But at the same time, they have come with a real cost to legitimacy in light of broader judicial discretion. And to a certain extent, we can say there's been a sharp decline in the level of public faith in the court system. It seems to me that the introduction of technology into civil proceedings can ameliorate some, not all, but some of these difficulties in two ways. First, the digitization and automatic processes curb discretion, enhance consistency across cases and judges. Think about conditions under which certain types of motions are granted, alimony awarded, etc. Second, the documentation that comes with digital communication, the digital trail, right, allows for greater transparency and ex post monitoring. Judicial decisions have more supervision, either directly, formally, through appeal, or informally and indirectly through the media and the general public. This, I claim, will not only increase the effectiveness of the system, but will also heighten its legitimacy. There are all kinds of ways in which this NGCS project can be extended and broadened and improved. But the first step, I think, of what is needed is a paradigm shift from an efficiency perspective to a richer approach. Thank you.